like you. Be strong to hold the powers of the sun. To dream, believe.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And I've got a bunch of stuff for you on this one, folks. I've worked nonstop, and I think you're really going to be enlightened by the end of this video. I'm really starting to enjoy this investigative journalism, and I've put together some real information for you in this one, and I think things are looking up. And as I mentioned in the last video, gloves are off, the fight is on. And we've got some more information that just came out. I'm going to cover all of it with you in this video. Number one, the attorney that is now working the case is Bab Barlo. And I think that is probably the perfect scenario for the team now. In the order for proving Bicca, so she is going to be actually a part of the litigating team. It's Ann Taylor, Bicca, Massoff, and they have demoted Logsdon to, he's not going to be a trial attorney. He's just going to be still a consulting attorney, but he will not be participating in the trial. And we know that's a win. But I've gone through and I've done a lot of research on Ms. Barlo, and she is amazing. And the research that I have done on her and some of her past cases and some of the work she's done on this case, it is all correlating together. And I'm going to show you that in this video. In a little bit, I'm going to need you to put your thinking caps on because it's going to get real. And this information is amazing. And I think she is the perfect person to be able to get this across to a jury. In fact, I'm not so sure that they may need to use the presentation that I'm going to show you in this video to that jury, because it is very accurate and it is mind-blowing when you put it all together. We're going to talk about some other things that have hit the court docs, some amazing news. For example, there's been a couple of things on the transcripts that are about to be released from the closed hearing. It's showing some of the redactions that the judge approved and one that he didn't approve. And we can glean a little bit of information from just the redactions. But also, he released a order yesterday, it hit the court docs, that he is releasing the audio of the closed hearings from back in 2023 and one in early 2024 on the closed hearing audio, I guess the audio versions of, I'll read them to you here in just a minute. We'll look at that court doc. But with that happening, releasing 2 audio versions of closed hearings we never got to hear, releasing the transcripts of that hearing that we've been waiting on, all the things that just came out in these opinions. We have so much more information that we have now and is going to be coming to us here like promptly, that it's unreal. We'll be able to really get some good insight to some facts in this case. So I'll just tell you right now, I've already adjusted my schedule. I was going to go back to work in March. I've put it off now till April officially. So I'm on this thing full time right now. So I work for you, and I don't need anybody, trying to send me money. I don't have cash apps and all that kind of crap that these people ask for. I don't do it for that. And in fact, just so you know, just the views alone that I'm starting to get on my videos now, it's actually providing enough income to sustain us, so we can take the extra time off and focus on this case. So Thank you for watching the videos, and that's absolutely helping me. Thank you for all my members out there. That really helps. But I'm not up here asking you to cash app me and all that kind of crap. I can't stand when they do that stuff. All right, just the fact that you're watching the videos, I appreciate you. But I work for you now for at least till April, and I'm going to focus in on this stuff. I'm going to figure out how to get a hold of these, these audio recordings of the hearings and other things. But anyway, we're going to get right into it. We're going to focus on, first of all, I'm going to show you the court docs as it relates to those transcripts that they're going to be releasing, and the audio versions that they're going to be releasing. Then we'll take a look at the redactions that the judge approved from the transcripts that are coming out from that last hearing. Then we'll look at the court doc that approves Bab Barlo being an attorney. Then we're going to get into Bab Barlo, her background qualifications, her education, pretty strong, let me tell you. And then we're going to get into some of the information that I learned from her previous cases that applies to this case. I mean, almost exactly applies to this case. I'm going to show you some research that I've done based on that release of the court docs from the judge's opinion on the IGG that tells us the details on how Othram took the sample, what they did with it, what the FBI did with it. And then I'm going to show you what I'm calling the snowball effect. That is absolutely what happened in this. And the snowball effect I'm going to show you actually leans less towards, underhanded, just devious acts, and more towards maneuvering some facts to make them fit, like we've seen in all the other evidence that they had in this case. So please hang in there with me to the end of this one, because I assure you, you're going to get some real information in this video that is going to enlighten, and it's going to give us one step closer to the end of this thing and getting this guy exonerated or found not guilty, whatever you want to say, because that is the only acceptable outcome in this case. That is the only acceptable outcome in this case, because we know now, based on everything that we've learned, that there's no way that kid could have done this thing. So with all that being said, let's get started. Okay, we're going to start with the order from the judge granting the motion for pro hoc vice, as everybody enlightened me on. Thank y'all. The court, having considered the motion for pro hoc vice admission, being fully advised in the premises, good cause appearing, now therefore it's ordered Bab Barlo be admitted pro hoc vice in this case, and that Ann Taylor serve as local counsel, whose attendance shall be required in all court proceedings in which Bab Barlo appears, unless specifically excused by the court. It is further ordered co-counsel Lisa G. Massoff will remain in her position as trial counsel. Co-counsel Jay Logsdon will remain as consulting counsel, but will not participate as trial counsel. So out of there, Logsdon. In there, Miss Barlow. I think that is an excellent move, and I'll tell you more here in a minute. Now, also he released this order authorizing the release of court record audio recordings like I was talking about. And you can see here that the state shall be provided with audio recordings from the court proceedings held in Latah County on October 26, 2023. And that was the defendant's motion to dismiss indictment on grounds of biased jury. And that was a closed hearing. So they're going to release the audio recordings of that. And they're going to release the defendant's motion to dismiss indictment on grounds of error in grand jury instructions. Open. Wait a minute, that was an open hearing? Well, so that one we've already seen, I guess. And January 26th, why were they going to release something that was open? Defendant's motion to reconsider orders and motion hearing, defendant's motion to reconsider orders and scheduling conference. So this one was closed. This one, I guess, was open. But that's two more closed hearings that we're going to be able to at least get audio recordings on. And I'll have to figure out how we get these audio recordings so we can go through and glean all the information we possibly can from them. Okay, now this was the order that he just released, redacting portions of the January 23rd closed hearing transcripts. Okay, so this one is interesting. The state has identified 4 categories of redactions, and it references the name of witnesses, of a witness and roommate of the victims. Okay, so one of them, the redaction is for the name of a witness and roommate of the victims. So I'm thinking this one right here has to do with Bethany. Inquiries by defendant related to his Frank's motion. This is interesting, which the state objected to and was sustained. So that means that they were talking about other issues other than the IGG in that closed hearing as it related to the Franks. The state objected to it, and of course the judge sustained their objection. Names of defendants' distant relatives identified through IGG, well, that one makes sense to redact. And individuals who are identified as potential relatives of defendant through Othram Laboratory IGG. Now, this statement right here, I think we can really figure some things out from, because this one, number 3, is different than number 4. So number 3 is names of distant relatives identified through IGG. So these are actual relatives of Kohberger's. But individuals who are identified as potential relatives of defendant through Othram Laboratories IGG. That doesn't say defendant's distant relatives. That says as potential relatives of defendant. That means these 4 brothers, they were probably not even defendant's relatives. Those weren't even Kohberger's relatives that Othram identified. And the court finds that the redactions are appropriate as to categories 1, 3, and 4. Now, this is kind of big, and I'll show you in just a second. The individuals' names are exempt from public disclosure. Public release would constitute an unwarranted invasion of privacy. But it says right here, 1, 3, and 4 can be redacted. The court does not find it appropriate to redact the information in Category 2. And this is good because Category 2 was long. The fact that the court sustained the state's objection to defense's counsel inquiries does not make the line of inquiry confidential or otherwise subject to sealing. Further, the portion of the transcript in question does not reveal new or other evidence known to the public. Okay, so what that's stating is, all right, so the judge approved 1, 3, and 4. He did not approve 2. Let me show you. So this is the proposal from the state. All right, so the state proposed their redactions. That what I just showed you was the judge order on those redactions. But look at this. So the one that he approved is number 1, page 25, line 6 to page 26, line 21. So quite a bit of information that he's redacting right here, though, that we're not going to get to see. And of course, this refers to a witness and roommate of the victims. I'm going to say this probably is Bethany Funk, whose identity has been protected at least in part due to hostile public and social media postings. This portion of the transcript relates to a question by defense counsel to which state objected, and the objection was sustained. I bet every time the state objects, he sustains an objection. What's funny is I haven't heard any objections in any of the open hearings, so they're saving all their objections for the closed hearings. And you can bet this is the defense bringing up the information about Bethany and what she had seen, the exculpatory information. The state was objecting to it because they didn't want to even bring it up, and then the judge sustained it, which is ridiculous. But that part's going to be redacted, so we're not going to get to see line 6 on page 25 all the way to line 21 on page 26 as it relates to probably Bethany. Now, number 2, the state wanted the judge to take page 28, starting at line 12, and all the way through page 31, line 18. So 3 pages of transcripts. They wanted all that to be redacted. And it says this portion of the transcript involved inquiries by the defendant related to a separate Frank's motion instead of the relevant IGG topic. Again, this was the stuff that they were going over in that hearing that didn't have anything to do with the IGG. Like the portion listed immediately above was objected to by the state, and the objection was sustained. So, of course, they objected. The judge sustained it, sustained that. But this one, they were wanting 3 pages. The judge said no. This one, they're not going to redact, so we're going to get to see what the state wanted hidden right here. And what's cool is as soon as they release those transcripts, I'm going right to page 28, line 12, through page 31, line 18, and see what the state didn't want us to see. Number 3, this one will be redacted. Line 6 through 8 on page 151, and line 6 through 8 and line 15. This portion of the transcript deals with the names of distant relatives of Kohberger. Okay, well that one's we can say is good. Page 153, line 9. This portion of the transcript relates to the Something brothers, who were also identified as potential relatives of the defendant through the use of IGG, and whose identities are subject to the prior judge's protective order. So who are these 4 something brothers, I wonder? Because they're not saying those are Kohberger's relatives. They're saying those were potential relatives found by Othram. So very interesting. And then it just has some legal language in there, but that gives us, quite a bit of insight into what we're going to see in those documents. So, all right, now we're going to learn a little bit more about Miss Barlow, and then we're going to get into some real facts in this case that will blow your mind. And he got out of his cage again, and started writing an opinion on one of the things that I posted the other day. We'll talk about that at the end. Don't worry, I've got my guy looking for him now. Okay, so you see Miss Barlow right here, Forensic DNA Consulting. But let's look at her biography. Bab Barlo received a Bachelor of Science degree from the University of California, Berkeley in genetics. So California, Berkeley, that is a big school in genetics. She pursued her scientific and academic interest and obtained a Master of Science degree from Cornell, big-time school, university, in the field of genetics and developmental biology, with minors in plant molecular biology and cellular biology. She's a genius. Ms. Barlow's studies focused on the molecular mechanisms for controlling the expression of genes during development in plants and yeast. Ms. Barlow moved on to the law and obtained her Juris Doctorate from the University of San Francisco of Law, graduating magna cum laude. So she didn't just, go to school, get a master's in molecular biology and cellular biology, but then she goes and goes to law school and graduates magna cum laude. This young lady is, she is very, very sharp. After serving as a research attorney for the criminal division of the San Francisco Superior Court, Ms. Barlow opened her private criminal law practice. From the beginning, she focused on DNA cases. During her time in private practice, Ms. Barlow acted as an attorney consultant on over 200 DNA cases at all stages of the proceedings, from trial to post-conviction in federal and state courts. In 1998, Ms. Barlow, along with lead counsel Michael Burt, conducted the first successful challenge in the United States to the admissibility of STR evidence in the case of People versus Boken. Ms. Barlow was DNA counsel in a capital case in 2000 that resulted in a life verdict. Oh. Ms. Barlow was also co-counsel in a capital post-conviction case in R.E. Dennis Lawley, in which she was responsible for the handling of tool mark evidence. This evidence was the only physical evidence linking Lawley to the homicide. Later, the evidence that the gun found in Lawley's possession was the murder weapon was disproven by the discovery of the actual gun, found buried in a field over 20 years after the crime. In 2004, Ms. Barlow became the DNA attorney for the San Francisco Public Defender's Office, where she acted as an in-house expert, consulting with attorneys on cases involving DNA evidence and acting as co-counsel, primarily on homicide and serious felony cases. In 2013, Ms. Barlow returned to private practice. She now specializes in cases involving forensic DNA evidence throughout the United States. Her experience covers all types of cases and includes STR-based DNA testing, mitochondrial DNA testing, and Y chromosome STR-based testing. So she's got many, many years dealing in cases like this, especially as it relates to the only piece of evidence that really is strong against Mr. Kohberger, which is the DNA. So I think she is the perfect addition to the team. Thank you, Miss Barlow. Okay, so this is the order on defendant's motion to suppress the genetic information. This one is key. And we're going to go down here to findings of fact. So this is what the judge has written in his opinion. And I'm going to show you some key information here. On November 13th, 2022, law enforcement found the bodies of Maddie, Kaylee, Xana, and Ethan inside a residence located at King Road, Moscow. All 4 victims died from apparent knife wounds. A K-bar knife sheath was found on a bed next to the bodies of Miss Mogan and Miss Gonzalez. Law enforcement seized the knife sheath and swabbed around the button of the sheath for DNA. So swabbed. We know now it was a swab, not a vacuum. A sample of DNA identified as Q11. Q11 was the sample. It was extracted from the swab by the Idaho State Police Forensics Lab and subsequently tested using standard DNA STR short tandem repeat methods. The STR profile developed revealed that the DNA came from a single source male profile. Law enforcement uploaded the DNA profile to CODIS database to the CODIS. Well, I just noticed this little square right here, to the CODIS squared database. But it resulted in no hits to known offenders. Subsequently, law enforcement made the decision to pursue forensic investigative genetic genealogy, IgG, testing on Q1.1. So this is the same sample, Q1.1. They used it to make a DNR short tandem repeat. So that is Q1.1. So they sent Q1.1 the same exact thing to Othram, which was just the STR profile. Such testing begins with the generation of a large amount of raw sequencing data from the DNA sample, which is then organized into SNP. Such testing begins with the generation of a large amount of raw sequencing data from the DNA sample, which is then organized into SNPs or single nucleotide polymorphisms. Using bioinformatics software, the SNPs associated with ancestry and genealogy can then be pulled out of the raw data and organized into an SNP profile. So all they did was take the STR profile using bioinformatics software, pulled the data out of it and organized it into an SNP profile. We know they didn't use the same matter because all the matter was used in Q1.1 to create the DNA STR profile. If not, then this would be Q1.2. But it's not. It's the same one. So all they did was take the STR profile and create the SNP profile using bioinformatics software. And in turn, it was uploaded to commercial genetic genealogy databases to search for a genetic match. Depending on the strength of the match, law enforcement can start building a tree to identify potential genetic relatives of the uploaded SNP profile. The IgG was first performed by Othram Labs, a company with which Idaho Department of Purchasing had an existing contract for such work. No, the Idaho Department of Purchasing actually funded Othram Labs. They didn't just have a contract, they actually had funded their research. Othram was asked to develop an S&P profile from Q1.1, not a different one, not Q1.2, Q1.1, the STR profile. Upload it to those public genealogy databases permitting law enforcement entry and submit a preliminary report of its findings. Othram was not asked to ascertain medical information with Q1.1, nor is there any evidence it tested for such. The Idaho State Police delivered Q1.1 to Othram on November 22nd, 2022. Othram developed an S&P profile from Q1.1 and searched Family Tree DNA and GED Match Pro. This work revealed 4 brothers of interest. Who are these 4 brothers of interest that they revealed? All of whom were low matches, to Q1.1. To further its family tree building, Othram asked the Idaho State Police to contact one of the identified brothers to provide a DNA sample to upload into either of the 2 databases. Despite the Idaho State Police's request, the contacted brother declined to provide a sample. He was like, no way, am I giving you my DNA so you can, falsify a case against me or my brothers? But then on December 10th, we got dates now. Members of law enforcement, remember if I put this December 10th into our other timelines with what was happening with Farley and Leonard and all of that, and Kopaka, it would fit in just perfect, wouldn't it? Members of law enforcement, including the FBI, had a meeting to discuss Othram's work. They had a meeting to discuss Othram's work. We said, no, Othram is the premier lab in doing this. Let's talk about their work. I think we can do it a little better, they said. As a result, a decision was made to turn the IGG work over to the FBI. That same day, Othram was instructed to stop work, turn over its S&P profile, and search results to the Idaho State Police. Othram did so, along with a preliminary report of its findings. The preliminary report did not contain any medical information associated with the S&P profile. That's about the 3rd time they brought up the medical information, which one of the things they can find in that medical information is the fact that Mr. Kohberger's alleles could actually show past narcotics use. So did that play a part in it? I know it didn't because it's not his freaking profile. The Idaho State Police then turned the information over to the FBI. Now people that were trying to say that it was the Idaho State Police that doubled the size of the profile, this is why I say you got to have eyes to see and ears to hear to figure this stuff out. The Idaho State Police then turned over the information to the FBI, which was able to use Othram's profile to develop a significantly larger S&P profile. The FBI is the one that doubled the size of the profile. No more questions about that. The FBI uploaded the larger S&P profile to multiple genetic genealogy databases, including GED Match and MyHeritage, which purport to disallow law enforcement searches. So it was the FBI that somehow took the Premier Lab's ability to create an S&P profile and made it much larger somehow. I wonder how they did that. Well, maybe because GED Match contained Bryan Kohberger's DNA, and they took his DNA from GED Match and added it to the digital S&P profile. That is what I believe happened. But from the information it acquired through the database search, the FBI was able to build a family tree and arrive at a potential match. On December 19, 2022, the FBI provided defendant's name to Idaho law enforcement as a possible source of the DNA. The FBI instructed that the identification of defendant as a person of interest was to be considered solely as a tip. And yeah, we believe that, right? But now we've got all of the purported facts of the case as it relates to this. Now let's see what those facts tell us. So on 11/13/2022, the knife sheath was collected from the crime scene. A partial STR profile was generated between 11/13 and 11/20 of 2022. It doesn't say the exact date that they pulled the DNA and all that, but it does say that they entered the profile into CODIS on 11/20/22. So we know what happened in between that time. Now, I am contending that that sample that they got off of the knife sheath was a partial STR profile. And all the evidence we see in the court record leads us to that, and all the research we do on touch DNA and especially on brass lends us to believe that. So what I believe happened is there was less than 8 genetic markers due to the degraded sample. You have to have 8 to 13 markers to successfully upload this profile into CODIS. But if it has less than 8 genetic markers, can they still upload it into CODIS? Well, not necessarily unless they do something to it. And that's where the work of Miss Barlow really comes into play. You see, in 2004, California gave San Francisco funding for DNA testing in cold case murders. A swab containing sperm taken from Sylvester's mouth was retrieved and tested. The usual number of genetic markers used in DNA testing is 13. Such markers contain less than 1/millionth of the information in the human DNA molecule. In Sylvester's case, only 5.5 genetic markers were usable, and they were mixed with markers from another person, presumably Sylvester herself. That was too little information to search California's 338,000 person DNA database. However, an analyst added another 2.5 markers to obtain the minimum number necessary to scan the database by extrapolating from markers that were so faint they were inconclusive. The database comparison using the extra extrapolated markers turned up a DNA hit on this Puckett guy. At his trial in January of 2008, there was no direct evidence to tie Puckett to the 1972 crime. The DNA hit, his criminal record, and the fact that Puckett was in the Bay Area when Sylvester was killed was the only evidence linking him to the murder. None of the 28 sets of fingerprints found at the crime scene matched Puckett. So all they had on Puckett was his DNA and the fact that he was in the city. And that got him actually convicted. They overturned it later. But this was a case that Miss Barlow was working on. But she uncovered the fact that they only had 5.5 genetic markers, but to make the 8 necessary to enter it into CODIS, the analyst added 2.5 markers to it. Where did they get the 2.5 markers? Well, you can see this example of an STR profile. This is an example of a degraded sample. You see, they're only supposed to use the long markers in the profile. Well, what they did was go down here to these short markers that don't really tell you anything, and they added those markers into the profile to complete it, which would then give very unpredictable results. I believe that is what happened in this case, because when you do that, it makes further matching to a suspect with an STR match, like to Kohberger's buccal swab. It would make it a lot easier for them to declare it is a statistical match. And we'll get further into statistics here in a minute. So, if we look at it like this, looking at the same timeline, the sheaf collected on the 13th, they swab it, create an STR profile somewhere between the 13th and the 20th. On the 20th, they enter it into CODIS after completing the less than 8 genetic markers with the shorter markers. A partial STR profile was completed using the additional faint markers, like I said, on 1120. The STR profile was entered into CODIS 1120. No match was found. So they send that profile to Othram, not the actual genetic material, but the actual STR profile. Q1.1 was sent to Othram. The profile was sent to Othram Labs on 11/22, and an SNP was created from the STR profile. Now, let's talk about how they create an SNP profile from an STR profile. Now, this is what I found in all the research that I've done on this particular subject, and it's conclusive. It is not possible to directly create a full SNP profile from just an STR profile because they analyze different regions of the DNA, meaning you cannot extrapolate SNP information from STR data alone. To generate an SNP profile, you would need to obtain a separate DNA sample. We know they didn't do that in this case because they worked straight off of Q1.1 and performed specific SNP genotyping tests on it. Using only an STR profile to create an SNP profile without actual genetic material is considered highly unreliable and not a viable method in forensic science. Well, funny to me, that's exactly what they did, but they didn't do it once. They did it twice. Othram did it from the STR sample the first time, and then somehow the FBI, using the same stuff, made it even bigger. So they didn't do it once, they did it twice. But it's actually considered highly unreliable and not a viable method in forensic science, yet that's exactly what happened in this case. To generate an SNP profile, you would need to perform a separate analysis using SNP genotyping assays on a DNA sample. They would have to have a sample to do it accurately. But if a high-quality STR profile is available, now it's my belief they took a partial profile that didn't even meet the 8 qualifiers and completed it with the low copy number alleles. Researchers might use advanced computational methods to predict potential SNP variations based on population data, but this would only provide a very limited and uncertain SNP profile. This is exactly what they did. They used the advanced computational methods of Othram, and they predicted the SNP variations. And we know now that it only provides a very limited and uncertain SNP profile. But not only that, if the information that they predicted with their computational methods was from a profile that was already manipulated in a way, then how much more off would their SNP variations be? This is what I'm going to be talking about in a minute, is a snowball effect. It starts out bad and it just gets bigger and bigger. In research settings, studies might explore the possibility of using statistical models to infer, that means guess, some SNP information from STR data, but this would be highly complex and require extensive knowledge of population genetics. Well, we can assume that maybe Othram has extensive knowledge of population genetics, but still all they're doing is using statistical models to infer the SNP information. So by doing it from a sample that was already manipulated, they're inferring bad information. This whole thing stinks. And this is why I think Bab Barlo was the perfect person for this. So, again, knife sheath collected on the 13th. It was swabbed. They created an STR profile. They entered it into CODIS on the 20th, but that profile didn't contain 8 genetic markers, so they had to use the smaller alleles to complete it, which makes it an unreliable sample to start. Then, A partial profile was completed using the faint markers entered into CODIS on the 20th. Couldn't find anything because it wasn't even a completed profile. Then they send just the STR profile, Q1.1, to Othram, and Othram, that was on 11/22, and Othram used computation from their computer to infer an S&P profile created from the STR profile. So they used a bad STR profile and their computer, and they generated an even worse S&P profile. The profile was created using the original STR by predicting with a computer the S&Ps. Oh, but when it comes over here, if the original profile was completed by adding markers, then the prediction for the S&P wouldn't be correct. But then look, the FBI takes the sample on December 10th and somehow enhances it even further. The FBI enters the sample into the genetic genealogy databases and gets a match on December 19th. BCK's STR is statistically matched on December 30th from the buccal swab to the original STR profile, and the statistics were 5.37 octillion to 1, which every mainstream moron says is undeniably a 100% match. And that is not what that means, and this is where Bab Barlo comes in again, because the statistical matching is almost always manipulated by the crime labs. You can see one of the prosecution's DNA experts testified that the chances of a random match to the DNA recovered from Sylvester was 1.1 million to 1. Another gave his own likelihood ratio as 1 in 152 billion. The jury convicted Puckett, but only after sending a note to the court asking how he had become a suspect, a question the judge refused to answer. Does that sound familiar? Like in this case, the judge won't answer how he really became a suspect, but the jury convicted him anyways because of the 1 in 152 billion match. But look at this. At a pretrial hearing, Bab Barlo, a DNA specialist for the San Francisco Public Defender's Office who has a master's degree in genetics, had testified that the match probability statistics were wrong. The problem was that the 1 in 1.1 million statistic applied to a random match to a single individual. That doesn't hold true when you began comparing DNA profiles with huge databases of DNA samples. Then, according to two panels of scientific experts convened by the FBI and the National Research Council, the chances of a random individual match should be multiplied by the number of samples in the database. They said they had 337,000 samples. So when you multiply 1.1 million by 337,000, it gives you the actual match. That would change the odds of an innocent person receiving a DNA hit in Puckett's case from 1 in 1.1 million to approximately 1 in 3. Yes, 1 in 3. So when they do these bogus statistical matches like 5.07 octillion, they are supposed to multiply that match ratio by the number of people in the database. They were taking 1 in 1.1 million and not multiplying it by the 337,000 that was in their state database at the time, which gave them a 1 in 3 match. But when you use the same statistics and you apply that to the Bryan Kohberger case in that 5.37 octillion match, and thank goodness Miss Barlow actually has put it in there. And you see what the actual ratio is. Because in the CODIS database, there are millions of people in there. So they should take the 5.37 octillion and multiply it by the millions in the database to get the real statistic. And here it is. In this motion, the government misstates the statistical rarity of the comparison to the DNA from the sheath. The STR profile is at least 5.37 octillion times more likely to be seen if defendant is the source than if an unrelated individual randomly selected from the general population is the source. This reported statistic for this comparison is a likelihood ratio similar to a RMP, which compares two competing hypotheses. The government statement is extremely misleading and is essentially the prosecutor's fallacy. Fallacy means fake, lie. It's prosecutor's lie. The fallacy is to say that the probability is also the probability that the DNA at the crime scene came from someone other than the defendant. It does not say that the odds that the suspect contributed the evidence are 1,000 to 1. So it's 1,000 to 1 that Bryan Kohberger's DNA was on that knife sheath. National Research Council, the Evaluation of Forensic DNA Evidence, 1996, at page 133, Declaration of Bab Barlo at 9. So not only is it not a 5.37 octillion perfect match, it's 1,000 to 1 that it's not Kohberger. Stew on that one for a minute. That's why I believe Ms. Barlow is the perfect person to be able to explain this to a jury. But I think this is the best way to explain it. And it's what I call the snowball effect. And everybody knows what a snowball effect is. The snowball starts out small. As it rolls downhill, it gains more snow, and then by the time it gets to the bottom, it's a big snowball. Well, if you take that and you apply it to the facts in this case, we've got sample Q1.1 completed using inadequate markers by the ISP lab. So they took the less than 8 markers, used the information they weren't supposed to use to complete the degraded sample so that they could create a STR profile and enter it into CODIS. That's why they only got it was a male. Then they sent the STR profile that they created using the inadequate markers, the small snowball, and sent that profile to Othram. Othram then used their computer to infer from the information from the original STR profile and made an S&P profile and made that snowball even bigger because it took bad information. Now we got more bad information and a lot more of it. And then somehow, nobody can explain it to us, but somehow the FBI took the same profile from Othram and somehow made it twice the size that Othram did. Nobody can explain that because the FBI destroyed their work. So now that little bitty snowball that got bigger is a giant snowball. And it's a giant snowball of bad information. And that is what we're dealing with in this case. Now, I want you to just imagine that you're at the horse track. And you've got a horse that is 1,000 to 1 odds of winning the race. I mean, that would literally be a donkey lining up with, with strong horses. How much money would you put on that donkey to win that race? Well, that's the odds that are the true odds that it's Bryan Kohberger's DNA on that knife sheath. Would you bet a lot on it, Gilters? I wouldn't. But even if that original STR profile wasn't a partial sample, let's say somehow it was a full STR profile, everything else still applies. It says that the science on creating S&Ps from that STR is unreliable and shouldn't be used. They did it twice. And then the statistical match, even with that being a completed STR profile to that buccal swab, is still 1,000 to 1. It's not Kohberger. You add in the fact that we know that thing was a degraded sample. They more than likely had to pull those shenanigans to complete it just to enter it into CODIS and then start that snowball effect. Well, this thing is just plain as day a travesty. Plain as day. Now, I'm going to use some additional information to even further the argument. Oh, you got him? He's back in his cage? Good deal, because we're going to use that moron's so-called argument to bolster everything we just said. All right, get out of here. Let's take a look at this moron's argument that he posted trying to counter-argue what I said in a post the other day. And he tried to use the mainstream moron's reasoning for it, but it was even dumber. And that's why you know this guy is a dadgum federal agent. There is no doubt, because he tries to steer everybody's mind off the feds every time. Okay, so here is what I posed. I said, here's a question someone should ask. The FBI did not run the 2 unknown male DNA profiles through CODIS because they did not meet the subjective criteria. However, they broke their own policies and policies of private companies and ran the IgG through their databases. How do they justify one and not the other? Now, the argument when Bill Thompson said they didn't meet the criteria, Bill Thompson wasn't talking about the DNA samples were partial off of the blood and didn't meet the criteria. He was saying that the DNA samples were not found directly with the victims, so they didn't meet the subjective criteria of being directly connected to the crime, so they couldn't run them through CODIS. That was what he was saying. Even the mainstream morons agree that's what he was saying. But look what this moron tries to say. First, the FBI was not responsible. Yeah, why? Because you work for them? For running the profiles through CODIS. Yeah, you don't think the FBI could ask the Idaho State Lab to run those through CODIS? Give me a break. That is and was, in the Idaho 4 case, the purview of the Idaho State Police Crime Lab in Meridian. Actually, no, the crime lab doesn't make that determination, moron. The detectives on the case make that determination, not the crime lab. They do what's directed to them. If they say, here is a sample from a crime scene, run it through CODIS, they will follow their direction. They don't make investigative decisions. So that's your first mistake. But second, the determination of whether a profile is eligible for CODIS or not, meaning, look at this, meaning the profile either does or doesn't have the requisite 8-core loci for eligibility. Actually, no, that's not what it means. It means that the blood was not found near the crime scene, but in an algo and as such is not subjective. The interpretation and evaluation of any candidates from CODIS and whether or not they are deemed a match is subjective, assuming the profiles were eligible for uploaded into CODIS, meaning they had at least 8 core loci. So what this moron's argument is that the blood samples that were found on the handrail and in the glove, the crime lab was not able to generate STR profiles that had 8 core minimum loci. The blood. But in his same argument later, he is implying that they did have enough to complete an STR profile with the skin cells. He was stating that he didn't believe that it was a partial sample. That's why I say he's either a complete moron or he works for the FBI, because one only has to look a little bit deeper to see this. Obtaining a complete STR profile from blood is generally considered much easier than from skin cells, as blood typically contains a significantly higher concentration of DNA, making it easier to extract and analyze compared to the often minuscule amount of DNA present on skin cells left behind on touched surfaces, touch DNA, which can be more challenging to generate a full profile from. In most cases, not some cases, not a few cases, but in most cases, a complete STR profile can be obtained from a blood sample with high success rates, not low, not medium, but high success rates. While skin cells may require more advanced techniques and larger sample sizes to achieve a full profile. So blood, they can get a full STR profile easily. Skin cells from touch DNA, it is requiring more advanced techniques, larger sample sizes, and it is very challenging to develop a full profile. So moron, your argument makes absolutely no sense. That is your way of deferring or deflecting, I believe they say. The reason they did not run those STR profiles through CODIS is stated because they did not want to violate a subjective policy that the samples weren't found directly related to the crime, which you know is a bunch of BS. When you have 4 people unalived with a knife and you find blood on a handrail and blood in a glove, those are absolutely directly connected to the crime, and only a moron would say it wasn't. But not only that, even if you could subjectively say maybe it wasn't, the fact that they went through all those extra steps and broke the policies of their policies and those private companies' policies to run that touch DNA through that database, you're telling me they will do that, but they won't bend a subjective policy to run the DNA through the database from the blood? BS. And that doesn't make sense in anybody's minds. So good try there, moron, but try again.
Bryan and me with something here. We were all just a little kind of flummoxed by the did not meet the criteria. The 2 other blood samples, the one from the railing in the house, don't know if it's first or second floor, basement or middle floor, or third floor, or the blood in the glove found outside. What does that mean when the prosecutors might say it didn't meet the criteria to feed it into CODIS to try to match it up with other people?
Well, good to be back with you, Ashley. Hello, Bryan. So here's the deal. CODIS users have to adhere to some strict eligibility guidelines before you can enter a profile. And that's because back when Congress enacted the law back in 1994 called the DNA Act, it recognized that the creation of this database would contain genetic data. So they wanted to ensure that only the genetic information from criminal perpetrators was entered. And so the evidence here must be linked to the perpetrator. So, for example, if you have a murder that takes place at a party house, that's what you correctly describe this house as, investigators could seize empty beer bottles. And if there's a DNA profile on the beer bottles and the investigators want to send it up to CODIS, they cannot. It's ineligible because although it could be linked to a perpetrator, it could just as easily be linked to someone who's uninvolved. So they wanted to protect those who are uninvolved. So whether it's beer bottles or whether it's gloves found outside or handrails inside the house, which may or may not be linked to the floor where the murders occurred, it's the same thing. They're not eligible to be entered into CODIS.
You see, that was the argument that they were trying to make as not eligible. And as I previously stated, for the reasons I previously stated, that argument is moronic. But your argument that blood couldn't be completed samples, but touch could, is even more moronic. A lot of mainstream morons out there. Mainstream morons. That's MSM. Used to be the mainstream media. Now it's the mainstream morons. But hopefully all the information I provided you in this video is helpful. It is a lot of information to take in. You may need to watch it a couple of times to fully grasp it, but it is important for you to grasp it because understanding where we're at in this case is key. I will continue to deep dive, go through the evidence, and I'll continue to bring you as accurate information as I possibly can. Thank you, Bubbly Waters, for putting out the rest of those indictments. All of those cash flow businesses that Gil had created. Well, after looking at all that and looking at the amount of money that was going through the hands of him and other members of that crew and the amount of narcotics and the sophistication with producing LLCs and manipulating their money through those, that was a very large and sophisticated operation, even more than I had given it credit for. So I am continuing to do some deep dives into that. But please like and subscribe to the channel. Post your comments, thoughts, criticisms. And until next time, Pavarotti is out.
Until I walk awake.